Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 3rd March 2025 and we bring you news that matters. The first news for today is as follows. In a significant development, the Supreme Court of India has expressed a preliminary view that identifiable users should receive notice before their social media content is taken down. This observation came during the hearing of a public interest litigation (PIL) challenging the current procedures under the Information Technology (IT) rules, which allow for the blocking of online content without notifying the original poster. A bench comprising Justices B.R. Gavai and A.G. Masi sought a response from the Union government on the petition filed by the Software Freedom Law Center. The petition contends that the existing IT rules violate principles of natural justice by not mandating notice to the originator of the content before its removal, thereby denying them an opportunity to be heard. Senior advocate Indira Jaising, representing the petitioner, argued that while the state has the authority under Section 69A of the IT Act to order the removal of certain posts, the lack of notice to the individual who posted the content is problematic. She highlighted that the current practice involves notifying only the intermediary platforms, such as social media companies, without informing the actual content creators. Justice Gavai noted that the rules could be interpreted to require that if a person is identifiable, they should receive notice before any action is taken against their content. He suggested that if the individual who posted the content is unidentifiable, then the intermediary could be notified instead. The court's remarks underscore the importance of adhering to natural justice principles in digital content regulation, ensuring that individuals are informed and given an opportunity to respond before their online content is removed. Next news. In a notable development, the Supreme Court of India has granted interim bail to former civil servants Soumya Chaurasia and Ranu Sahu, along with other accused individuals, in connection with the School Levy scam case. The bench comprising Justices Suryakant and N.K. Singh issued this order while hearing appeals against the 4th of November 2024 decision by the High Court, which had denied bail to the petitioners. The court emphasized the need to balance the petitioners' personal liberty with the efficient administration of the investigation, stating, "The release of the petitioners on interim bail is on a trial basis to strike a balance between liberty and fair investigation. The accused are charged under various sections, including Section 420 cheating, and Section 384, extortion, or the Indian Penal Code, as well as Sections 7, 15, and 12 of the Prevention of Corruption Act, 1988. They allegedly misused their official positions to assist the main accused, Suryakant Tiwari, in collecting extortion money from coal transporters, resulting in significant losses to the state exchequer. The Enforcement Directorate arrested the petitioners in 2022 under the Prevention of Money Laundering Act, PMLA, citing offences related to money laundering and conspiracy. Subsequently, the state police registered an FIR on the 17th of January 2024. The Supreme Court noted that the investigation is ongoing, with a supplementary charge sheet expected within 2 months. Given that hundreds of witnesses have been cited and the trial is unlikely to conclude soon, the court found it appropriate to grant interim bail. This decision underscores the judiciary's effort to uphold individual liberties while ensuring that investigations proceed without undue hindrance. Next news. The Supreme Court of India has reserved its judgment on a plea by Congress Rajya Sabha MP Imran Pratapgarhi seeking to quash a first information report (FIR) filed against him by the Gujarat police over a poem he posted on social media. During the hearing, a bench comprising Justices Abhay S. Aukar and Ujjal Bhuyan observed that the poem titled Akhun ke pyase baat suno conveys a message of non-violence and is not directed against any religion or community. Justice Aukar remarked, "This actually promotes non-violence. It has nothing to do with religion. This has nothing to do with any anti-national activity. Police has shown lack of sensitivity." The FIR, registered on the 3rd of January 2025, accuses Pratapgarhi of promoting enmity between different groups and making assertions prejudicial to national integration, among other charges. The Gujarat High Court had earlier refused to quash the FIR, leading Pratapgarhi to approach the Supreme Court. Solicitor General Tushar Mehta representing the state of Gujarat argued that the poem could be interpreted differently by the public and that Pratapgarhi should take responsibility for content posted by his social media team. Justice Aukar emphasized the importance of understanding freedom of speech and expression, stating, "Some sensitivity has to be shown by the police. They must at least read and understand 75 years after the existence of the Constitution. Freedom of speech and expression has to be at least now understood by the police." The court's decision is awaited, with implications for the interpretation of creative expression and its boundaries within the legal framework. Next news. The Supreme Court of India has lifted the restriction on YouTuber and cardcaster Ranveer Allahabadia, known as B Biceps, allowing him to resume his show The Ranveer Show. This decision comes after Allahabadia provided an undertaking to maintain standards of decency and morality, ensuring that viewers of all age groups can watch his content. Previously, the court had imposed a ban on Allahabadia's broadcasts as a condition for granting him interim protection arrest. This action followed multiple first information reports, FIRs, filed by the Maharashtra, Rajasthan, and Assam police, accusing him of obscenity related to comments made during the India's Got Talent show. During the hearing, Solicitor General Tushar Mehta criticized the content of the India's Got Talent show, describing its perversity as eating of another level. He remarked that the program was unsuitable for viewing by any audience, stating, "Forget a man and a woman, a man and a man can't sit together and watch the show." In response, Allahabadia's counsel, Dr. Abhinav Chandrachud, assured the court that future content would adhere to appropriate standards, featuring guests such as spiritual leaders and professionals. He highlighted that Allahabadia employs 280 individuals and relies solely on YouTube videos and podcasts for his livelihood. The court's decision underscores the balance between freedom of expression and societal norms of decency and morality in digital content creation. Next news. In a significant move, the Supreme Court of India has urged the Union government to formulate regulatory measures addressing vulgar content on online platforms, such as YouTube. The court emphasized that these regulations should uphold societal moral standards without infringing upon the fundamental right to free speech and expression. This development arose during the hearing of a petition filed by YouTuber and cardcaster Ranveer Allahabadia, known as B. Biceps, who sought protection against multiple first information reports, FIRs, alleging obscenity in his India's Got Talent show. Previously, the court had expressed strong disapproval of the language used in the show and highlighted the necessity for regulatory oversight. Justice Suryakant, leading the bench, remarked that while censorship is undesirable, online platforms should not operate without boundaries. He stated, "Just because you have commercial interests, it cannot be that you can say anything. See, the quality of humor he has. Humor is something the entire family can enjoy. Nobody feels embarrassed. Using all filthy language is not talent." Solicitor General Tushar Mehta concurred, emphasizing the need for a balanced approach that preserves decency and morality without unreasonably impinging on freedom or expression. The court suggested that the government draft regulatory measures, place them in the public domain to invite feedback from stakeholders before implementing any legislative or judicial actions. This initiative underscores the judiciary's commitment to balancing the preservation of societal moral standards with the protection of fundamental rights in the digital age. Next news. In a landmark judgment on the 3rd of March 2025, the Supreme Court of India declared that individuals cannot be excluded from judicial service recruitment solely due to physical disabilities. The court invalidated a provision in the State Judicial Services rules that barred visually impaired and low vision candidates from such appointments. The bench, comprising Justices J.B. Pardiwala and R. Mahadevan, emphasized that persons with disabilities, PWD, must not face discrimination in their pursuit of judicial careers. The court asserted that the state is obligated to implement affirmative actions to ensure an inclusive framework, stating, "Any indirect discrimination that results in the exclusion of persons with disabilities, whether through cutoff or procedural barriers, must be interfered with to uphold substantive equality." The judgment arose from a suo motu case concerning Rule 6A of the State Services Examination, Recruitment and Conditions of Services, Rules 1994, which previously excluded visually impaired candidates from judicial service. Additionally, the court struck down portions of Rule 7 that imposed extra requirements on PWD candidates, such as a 3-year practice period or achieving a 70% aggregate score. The court clarified that while educational qualifications and a 70% minimum aggregate remain applicable, they should not be contingent upon first attempt success or prior practice experience. Consequently, PWD candidates who participated in the selection process are now entitled to considerations for judicial service positions, provided they meet the revised eligibility criteria. This decision underscores the judiciary's commitment to fostering inclusivity and equality within the legal profession. Next news. In a recent judgment, the Supreme Court of India reaffirmed that arbitration agreements remain enforceable against the legal representatives of deceased parties. The court emphasized that such agreements do not terminate upon a party's death and can be invoked by or against their legal heirs. The bench, comprising Justices J.B. Pardiwala and R. Mahadevan, referred to the precedent set in Ravi Prakash Goel v. Chandraprakash Goel and ANR 2008, 13 SCC 667, which established that arbitration agreements persist beyond the demise of a signatory. Additionally, the court cited the Delhi High Court's decision in Jyoti Gupta v. Wilsons and Oz 2018 SCC Online Del 7942, reinforcing that legal heirs are bound by such agreements. The ruling arose from an appeal against a Guwahati High Court judgment that directed the legal heirs of a deceased partner to arbitration, despite their non-signatory status. The Supreme Court dismissed the appeal, underscoring that the term partners extends to legal heirs, representatives, assigns, or legatees. Consequently, both original parties and their legal representatives are entitled to enforce and are bound by arbitral awards. This decision highlights the judiciary's commitment to upholding the continuity and enforceability of arbitration agreements, ensuring that demise of a party does not impede resolution of disputes through arbitration. Next news. In a recent ruling, the Supreme Court of India addressed the approach high courts should adopt when encountering seemingly inconsistent decisions from the apex court. The bench, comprising Justices J.B. Pardiwala and R. Mahadevan, emphasized that high courts should not selectively follow one decision while disregarding another. Instead, they are obligated to attempt to reconcile both judgments and adhere to the one whose facts align more closely with the case at hand. The court underscored the importance of contextual interpretation, advising that every judgment must be read in relation to the specific facts or its case. This approach ensures that general expressions within a judgment are not misapplied beyond their intended scope. This ruling offers clarity on the methodology high courts should employ when faced with conflicting Supreme Court judgments, promoting consistency and coherence in legal interpretations across the judiciary. Next news. In a recent ruling, the Supreme Court of India emphasized that bail should be the norm when an appellate court invokes Section 390 of the Code of Criminal Procedure, CRPC, to arrest an accused during an appeal against acquittal or discharge. The court highlighted that an acquittal further strengthens the presumption of innocence, placing the acquitted individual on a higher legal pedestal than someone merely facing trial. Consequently, committing such an individual to prison should be reserved for extreme and rare cases. Furthermore, the court advised that high courts should exercise caution when considering stays on discharge orders issued by trial courts. Such stays should only be granted in exceptional circumstances where the discharge order is manifestly perverse, and only after providing the accused an opportunity to be heard. This ruling underscores the judiciary's commitment to upholding the principle that bail is the rule and jail is the exception, especially in cases where the accused has already been acquitted or discharged. Next news. In a recent ruling, the Supreme Court of India criticized the practice of seeking modifications to judicial orders or judgments through oral mentions, bypassing formal review procedures. The court emphasized that judicial verdicts must maintain stability and finality, stating they are not like sand dunes which are subject to the vagaries of wind and weather. This admonition arose from a case where a single judge of the Naa High Court, nearly 3 years after issuing an order, added an additional sentence following an oral request from one party without notifying the opposing party. The Supreme Court deemed this approach improper and contrary to judicial propriety, underscoring that modifications to orders or judgments should not be pursued through oral mentions, but through the appropriate legal process of filing a review. The court imposed a cost of 1 rupee lakh on the appellant for attempting to circumvent established legal procedures, reinforcing the necessity for adherence to formal processes to uphold the integrity and finality of judicial decisions. Next news. In a recent judgment, the Supreme Court of India clarified that advocates are not criminally liable for failing to verify the authenticity of a power or attorney provided by a litigant. The court emphasized that in the ordinary course of practice, lawyers are not expected to ascertain the genuineness of such documents. This ruling arose from a case where an advocate faced charges under various sections of the Indian Penal Code, including those related to cheating and forgery, for filing a tenancy case based on an allegedly fabricated power or attorney. The Supreme Court noted that Vakalatnama authority to represent was signed by the power or attorney holder, and the petition was duly signed and verified by him. Consequently, the court discharged the advocate, stating that no case was made out to proceed against him. This decision underscores that while advocates have a duty to represent their clients diligently, they are not obligated to verify the authenticity of documents, like powers of attorney, unless there are apparent reasons to doubt their validity. Next news. In a recent judgment, the Delhi High Court clarified that the Appellate Tribunal for Foreign Exchange (ATFE) does not possess the authority to declare individuals guilty under the Foreign Exchange Regulation Act (FERA) on 1973. Justice Jasmeet Singh emphasized that such pronouncement fall exclusively within the jurisdiction of competent courts. The court highlighted that proceedings under FERA are adjudicatory and not criminal in nature. The ATFE functions as a quasi-judicial body, responsible for administrative and adjudicative tasks, but it is not classified as a court. While the tribunal can impose penalties for FERA violations, it lacks the mandate to declare someone guilty of offenses under the Act. This clarification arose from appeals filed by M.S. Sujana Steel Limited (SSL) and its chairman and managing director, challenging an ATFE order that imposed penalties and labeled them as guilty. Delhi High Court upheld the penalties but directed that the term guilty be expunged from the tribunal's order. The court referenced the Supreme Court's decision in Director of Enforcement (VMCTM) Corporation Private Limited and others, which established that the ATFE's role is to determine liability for FERA breaches, not to adjudicate criminal guilt. This ruling delineates the boundaries of the ATFE's authority, reinforcing that declarations of guilt are reserved for judicial courts, while the tribunal's role is confined to assessing and penalizing regulatory violations. And the final news for today is as follows. In a recent judgment, the Telangana High Court ruled that employees reinstated after wrongful termination are entitled to back wages if the employer's service rules do not explicitly permit withholding pay for the period out of service. The case involved an employee of the Karimnagar Cooperative Urban Bank, who was demoted and denied back wages for the duration he was out of service. Justice Namavarapu Rajeshwar Rao observed that the bank's service rules did not authorize penalties, such as dies none, a period treated as non-existent for legal purposes, or withholding of salary, remuneration. Consequently, the court held that imposing such punishments was contrary to the established rules. The court referenced the Supreme Court's decision in Vijay Singh v. State Ord, emphasizing that in a society governed by the rule of law, punishments not prescribed under statutory rules cannot be imposed. Therefore, the court set aside the bank's penalty or dies non and no salary, remuneration, and ordered the payment of back wages to the employee. This ruling underscores that employers must adhere strictly to their service rules when imposing penalties and that employees cannot be denied back wages upon reinstatement unless explicitly provided for in those rules. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.